those two matters, and you will tell us what you think of those. Stay with us.
Do you want a healthy smile?
Ready for a smile makeover? Hi, I'm Tanya from Bethel Dental Clinic, Ghana. Cosmetic dentistry services can enhance your smile's beauty and boost your confidence with a more attractive and radiant look. Whether you're interested in teeth whitening, veneers, or a complete smile transformation, an experienced dental team can help you achieve the smile of your dreams. The process begins with a consultation where we assess your oral health, discuss your specific concerns and goals to create a tailored treatment plan. While smile makeovers primarily focus on improving the appearance of the smile, they can also offer functional benefits such as better bite alignment, improved chewing ability, and enhanced overall health.
Healthy smile.
Remember who we are singing now. At risk of prostate enlargement. We a member or her 20 ebitimia prostate cancer. 5 bitimi afamu na dia obefamu.
Actually, this is not my fault.
And to wada entina medi maniche Executive Prostate Center.
Executive Prostate Center is a unique medical center where we harmonize in-depth traditional medicine with cutting-edge science and technology to cure, to treat, and to prevent diseases like prostate enlargement, prostate cancer.
Executive Prostate Center. Madame facilities no any professional medical care.
Sisi a bibia clear system no. Ye nro ne so de natural. Into be koso afama ye.
Executive Prostate Center. My cured.
Fire pomudi ni agobio Ghana fueni age efri say ya your local spices na ya frafra dia ya sankofa natural spice
me de go me jollof mu ni mi sti wa hodoma e ma ne dance
Stanley the barbecue the go on
sankofa natural spice and one you use 100% natural said the happen
Adofo mamunye huge mistake sankofa natural spices the
FDA agi ejedi nkratu yatu
In a wide position, so what's next? Ronaldo. This could be. There's still danger here.
Goal! In 1924, my grandpa was a champion. 2024, Meso is a champion.
Hey, digital champion. It's about the end.
Digital champion, what can TV shop online?
Let me help you get what you need from Enterprise now.
It's this simple. I just log into my Enterprise account using the Enterprise Self-Service portal. Then I just click on this button for their new Advantage Point loyalty scheme. Then boom, the fun begins. Wow. Yes, once I start making purchases under any subsidiary, I can now earn a lot of points and redeem it as airtime, Momo, and more.
Hey, customers only.
Look at you. Even on your birthday,
you earn points.
Yes. Even when you like and share on the portal,
you earn points.
Yes.
Purchase an Enterprise policy today to enjoy this exclusive offer and start earning rewards. Because nothing you do should be pointless.
Oh, then redeem more of your points and send to me.
Hey, Mr. Digital Champion.
Enterprise, your advantage.
So tonight we explore two issues. The first one has to do with the embattled Chief Justice Gertrude Arabai-Sabat Tokonu, who filed an injunction on May 21 seeking to restrain a 6-member committee established by the president from proceeding with his inquiry into petitions submitted against her. She also requested the disqualification of 2 committee members, Justices Gabriel Puamang and Samuel Adibu Asiedu, citing concerns about conflict of interest and impartiality. However, in a unanimous decision, That's a very interesting way. Unanimous decision. The Supreme Court dismissed the application and says its ruling would be fully delivered on the 12th of June. Now, reacting to this, the former Attorney General and Legal Counsel, now to the CJ, has argued that the legal threshold for granting the injunction against the proceedings seeking her removal had been met in his view. Appearing before the Supreme Court on Wednesday, 28th May, which is today, the former Attorney General contended that no prima facie determination was made regarding the petition that initiated the CJ's removal process. He pointed out the President's letter to the CJ referenced a prima facie case only briefly in its third and fourth paragraphs without offering a detailed evaluation. We'll hear from Godfrey Dami shortly. According to him, this falls short of the constitutional requirement for a quasi-judicial process, including a prima facie assessment as outlined in Article 146 of the Constitution. He also said a few other things. So we're going to discuss this first, and then we'll move to the Chairman Wontumi case. In studio is Member of Parliament for Bongo, Charles Bawadua, who is a lawyer himself. Honorable, welcome to the show. Good evening.
Thank you. Good evening.
So quite interesting to hear the former Attorney General complain about the matter. We heard him talking about, he said the decision was strange. It seems as if people in the NDC are quite determined to push through this attempt to remove the former, the CJ who's been suspended. And therefore, I'm sure you will say that what the Supreme Court decided today was not strange and you were happy and expecting it, correct?
Thank you very much. Let me first of all say good evening to my constituents and your viewers as well.
All right.
Well, I think that we should look at these issues not on the basis of politics, not because one belongs to a particular party, NDC or MPP or any other party. I think we have to look at it on the basis of law. I mean, this for me, this is a purely legal matter, and specifically a constitutional issue. Our constitution is being called upon to be enforced, as has been provided in Article 146. That's how we should look at it. And at the end of the day, the outcome will be dependent on the facts and the legal processes that have been followed. It is not about one's political coloring. So it's not a question of me being happy or any NDC member being happy. I think it's a question of all Ghanaians, seeing and then observing that the legal processes have been duly followed. It can't be one of politics at all.
Well, the former Attorney General says he's surprised that the court could not see the glaring merit in the injunction application from the CJ. What do you say?
Well, I am surprised that he was surprised because, look, this is a constitutional process that was ongoing. Before you can injunct a constitutional process, you must have very good reasons. If you read, I mean, the affidavit that was attached to the application, and I have had the opportunity to also look at aspects of it. There is nothing substantial that will warrant the grant of an injunction. An injunction is a very serious order of the court to stop a certain action that is taking place. You must have very good grounds. They failed to adduce grounds or depose to grounds in their affidavit that met the standards for a grant of an injunction. And so, if the court, refused it, I'm not surprised that I'm surprised.
But he contends that no proper prima facie determination was made regarding the petition that initiated the removal process. He says there was just a perfunctory mention in 2 paragraphs, and so they don't even know the basis upon which that determination was made for even her suspension.
No, but that is his view. Let me also say that the processes of removing the Chief Justice requires it to be secretive. It requires that it to be held in camera. So you do not expect that there will be an elaborate enumeration of the facts, allegations, and all that has been alleged against the Chief Justice, or the basis upon which the President has made a prima facie case against the Chief Justice to be brought out. You understand? So he can't expect that in totality. Because the process expects that, one, the Chief Justice be protected, and then 2, of course, the judicial system also be protected. And so it's a constitutional process. I do not think that anything was wrong at all.
Well, earlier on, we understand the Deputy Attorney General had also tried to file a particular process to exclude some of the justices from the committee from this particular matter. The court did not agree with them. Any surprises there?
No, you see, this process, what the court is looking at in totality is to ensure that the constitutional provision as elaborated in 146 are complied with. Anything that will unnecessarily thwart that effort, the court would not agree. So you will see that it is not a political court. It gives a decision based on the facts and the law. And that is why it will make decisions against the Attorney General and also make decisions against the applicants. And that is why when a decision is not made in your favor, you ought not to see it as being political. It is just the legal process which is ongoing.
So as far as you are concerned, everything that's happening is very legal and therefore there's no cause for complaint.
I see no flaw anywhere. It's a very legal process, a constitutional process, a very clear one. And you see, Article 146, in my view, is one of the clearest provisions in that constitution. And it's so clear that it doesn't even admit of any interpretation. So there should be no doubt as to what Article 146 means. And so when it's being called upon, it's being enforced, and the facts support it. Unfortunately, the only problem with that, and I think it is for good, is that you are not able to see the full facts. So you have this perception that what is ongoing, and we don't have the full fact, but that is what the Constitution says, that let this be held in camera.
Okay. You know, when this matter came, a lot of people, or some people had said that we needed a CI to elaborate on the modalities for a removal of such a person. And in fact, yesterday, your leader, Majority Leader Mahama Yariga, now says government is going to introduce new rules on removal of Superior Court justices. So essentially, he recognizes that there needs to be some clearer rules. Aren't we putting the cart before the horse? Shouldn't this have been done before even this matter be heard?
No. But you see, Article 146, in my view, is very clear. You may want to add more, as some have suggested. But there is nothing ambiguous about 146. The desire by some people to have regulations or a CI that will elaborate some steps does not mean that the substantive provision, which is 146, should not be enforced. I mean, we are in this country, many laws have been enforced before the subsidiary legislations have come.
But my question is, why is Ayariga now saying that government will introduce legal reforms, including the introduction of detailed procedures for the removal of justices of the Supreme Court and other Superior Courts? So clearly, there's a gap there.
No, you see, what I'm saying is this.
In fact, he said these are intended to address gaps in the current constitutional and legal framework that have led to confusion and legal disputes in recent high-profile cases. He stressed that the proposed rules would bring much-needed clarity to the process and eliminate the ambiguities that have plagued the recent removal attempts. It's very clear that the leader of the majority obviously admits that there are challenges with the understanding or the operationalization of 146.
No. You see, the problems that I see is because the nitty-gritties of what steps to follow is not what has been provided in Article 146. But the meaning and extent of Article 146 is clear. But what steps should come after which the others should follow have not been provided for. And this is not new. You do not expect everything to be provided in the Constitution for every article. Otherwise, we'll have a very bulky document. So you will see that in some provisions in the Constitution, it talks of the minister or the government making regulations or a constitutional instrument to give more clarity to some provisions.
Yes.
You understand?
Yeah, but that's what people were asking for. Yeah, people were asking for, you see, nobody's saying the Constitution should be amended. They are saying that the current existing framework and Article 146 lacks sufficient procedural detail and leaves room for political interference. And I'm saying that Ayariga in Parliament, yesterday you were there, this is the first day of Parliament in this session.
Yes.
He goes ahead to say that there are vulnerabilities and therefore the need for clarity.
Yes.
And I'm saying that if that is the case, why, if this is, or is he now realizing it because of this case?
No. You see, Bernard, the point is this, that the lack of a CI giving detailed steps does not make the Article 146 inapplicable.
Okay.
It doesn't make it.
But it makes it subject to abuse.
It is clearer when the steps are spelled out. But the meaning and extent of it, as it exists now, is also clear. So you do not say that I will not enforce or apply Article 146 because a CI has not been passed.
But
Article 146 is not subject to the provision of a CI.
The CJ's problem with all of this is the way it's being operationalized. And Mr. Ayariga is saying that we need clarity. He says we need sufficient procedural detail.
Yes.
The woman is concerned about the procedure. She's not saying that Article 146 does not empower the president to remove it. She's saying that the procedure you've adopted is unfair. And I'm saying that from what your leader has said in Parliament, clearly he agrees.
No, you see, what the leader is saying is that, yes, it is good we have detailed steps as to how this could be enforced. It doesn't take away the fact that this article is still in effect and should be enforced.
I see.
You see, the extent of that article, how it should be issued, the president should go about it, the committee and how it is supposed to be set up, how a warrant can be issued by the president, and how same can be revoked, are all provided in 146. And so there is no doubt whatsoever the meaning of 146. And it is good to have, details as to what steps should come after the other. But that is just for purposes of clarity.
Okay.
But it has nothing to do with the effect, extent, and meaning of 146.
Fair enough. Point of view tonight is very legal. Tonight we're dealing with many issues. The CJ's matter, the 6-member committee looking into or essentially trying her in camera to essentially prove whether she has done anything wrong to merit her removal. We are digging into that. My guest in studio is MP for Bongo, Charles Bawa Dua. Let me digging into that. My guest in studio is MP for Bongo, Charles Bawa Dua. Let me go to one of our lawyers, public policy. He's been talking on a number of issues. He's following all these matters very, very closely. Just pick his quick thoughts on what's happened so far with the CJ matter before we move to the next issue. Mr. Kwebu, thanks for joining us. Good evening.
Good evening, Ben.
So it's good to have you, and I've kept you awake long for today. I was wondering whether the call by Mahama Ayariga yesterday in Parliament or the announcement rather, that government is preparing to introduce a comprehensive set of rules to govern the process for removing justices of the Superior Courts, including the CJ, whether that is not an admission of a certain lack of clarity in the procedure surrounding Article 146. This is how a layman like me sees it. What do you say as a lawyer?
Oh, definitely. It's an admission that Article 146 needs a lot of improvement, for lack of a better word. It needs a lot of fleshing up. It needs a lot of improvement. It needs a lot of efficiency. Yes, efficiency pumped into it and effectiveness. That one, nobody can run away from it. And Bernard, it didn't start today. The first call came about 20 years ago. In 2005 or 2006, the Frankie J. Chum case. That was the petition presented for the removal of Chief Justice Akwa. So when the Supreme Court went into the case, in their various opinions, the justices asked for rules, detailed rules, comprehensive rules to guide the process. They needed to do proper stewardship, right, to go through the process. And we had been playing football with it, or if you like, some would say kicking the can down the road. So we've kicked the can down the road for about 20 years now. So, and that has straddled many governments. And NPP, then NDC came 8 years, then NPP came another 8, and then NDC is back. So it's affected the two major political parties, and nobody can run away from it. Except that we cannot halt. I hope I'm not running ahead of myself.
No, you are fine. I wanted to ask that you've preempted my question. I'm saying that if the majority leader has now realized that we need procedural clarity, does that not mean that we are probably experimenting with this CJ removal in an atmosphere of uncertainty?
Yeah. Bernard, this one, the words that you have something to say. Your question certainly has something
No,
to
no, no. Let me phrase
say.
it. Let me phrase it again. You see, we have admitted that 146, in terms of the substance, is not a problem, but the procedure as to how it should be gone about needs more fleshing out. But I'm saying that this is we are taking a CJ through a process now, which in a sense we are admitting that that process needs more detail. So are we not putting the cart before the horse?
We are not, but that does not. I like your first question. I'll just say that it's too strong. But your first question was more. I mean, and it's better. You know, you have been in this business for decades. So sometimes you see, I laugh because it hit me, right? So I didn't think that it wasn't relevant. That's why I started by saying that you have something to say, except that it was too strong. Okay? Too strong, yes. So the truth of the matter is that it's not only 146 that needs more efficiency pumped into it. But now there are a lot of other laws that we need. Look, let me mention a common one, and I'm looking for people to partner me on it so that we can make Ghana a better society. Look at jail. I mean, people, remanding people. Look, Bernard, you know, at least from where you may own at least 2 houses, because I know you won Journalist of the Year, and then you got a house, and I know that
No. I didn't get a house for Journalist of the Year. I got a mattress sofa from Ash Foam. I didn't get a house.
Okay, but
so
okay,
I don't own 2 houses. I just own 1 house. Please.
Okay, but I don't, you're talking about mortgages extra.
So,
Bernard, you own a house. Now, does it make sense that tomorrow, God forbid, touch wood, for some reason you need to be detained there? Why should you be in cells, Iyoko cells, police cells, when a house arrest will do? Okay? So what I'm saying is that currently, our laws don't make provision for house arrest massively. Once in a while, when a big man in society is involved, then you kind of see some form of house arrest. I remember the last one we heard was this man, Timbila. But now, a lot of us, people own 5, 10 houses. And then you say, no, he should go and lie in some cells. So what I mean is that currently, our laws on bail, they are not the best. They are archaic, but we are using them. So we can't say that because they are archaic and some people are in custody, we should free everybody, go and improve the law before we come back. So that's just the example I wanted to give. So 146 has its challenges, but we can't say because CJ Tokonu is going through it, we should stop, go and amend the law before we come back. Then all the persons who are in custody now, Edubuahi, you see even the Mayfair properties and the other things, more than 30 houses, all right? Yes, he could have said no. He doesn't want to be in Iyoko cells. He wants to have house arrest. He didn't have that option. He was in Iyoko cells. So the same way Chief Justice Tokonu's own, we are here to improve the law. So for now, what we have is what we use.
All right, fair enough. Let me just get clarity on what happened in court today, because initially some of us were confused. Initially, we were told that the AG had made a certain application, I think, to disjoin 2 of the justices on the panel from the application that the former Attorney General had filed for the CJ. And the court refused that. But then the court also refused the application substantive that Mr. Dame filed for the CJ. I just needed to clarify that, because initially we were confused. Like, how can you say no to the AG and at the same time say no to the CJ? Because they are on opposite sides. So I need you to clarify that if you've been following, please.
Okay. So the former AG, Dame, says that, let's start with the current AG, Deputy AG. He says Scott Waman and all the members of the, what do you call it? The committee.
The committee, yes.
Yes. They should be struck out because they were performing official duties when they were sued. So Sremsai's argument is that they were performing official duties. So in that case, the suit against the Attorney General is sufficient to cover them. Then the Supreme Court said no. Once the reliefs are touching them personally, you can't say they should be removed from the case and the Attorney General should answer for them.
Okay.
No. So that's why. So AG says, Deputy AG says, people are doing official duty. If they did anything wrong, the Attorney General will answer. Supreme Court says no. They've been accused personally. So let them answer, even though personally, but through the AG. Even though personally, through the AG. Then Dami came with another argument that the AG should not even act for them. Dami was saying that, I've accused these people. The Tokoni is accusing these people personally. So AG should not act for them. Then the bench said, but it's the state that asked them to perform some public duties and they got sued. So it's only reasonable that the state should bear their legal fees by representing them.
Okay. So that's the first one that current Deputy AG filed. Then we understand that on May 21, CJ filed an injunction seeking to restrain the committee from proceeding with his inquiry whilst a substantive matter was on the cards. And I believe the court said no by unanimous decision. Correct?
Yes, correct. Okay, we should explain that. Yes.
Briefly, yes.
So you see the hearings going on. What's happening is that CJ Tokono has sued that, among others, will summarize. But I know she asked for 16 reliefs. So let me just use 2 or 3 to just demonstrate. 16 reliefs. She's saying that, listen, this trial is going on, but I don't even know how the president and the Council of State arrived at the prima facie, that's to say the decision that the trial should go on. The 5-member committee should be constituted and to go into the matter in details. She's saying, I've not seen it. And that one, I think there's some merit in that particular point. Yes. She's saying that, you see, ordinarily, if you go to a court, somebody has been accused of an offense, if at the end of the state's presentation of its evidence, the judge says that the accused should come and answer, the judge will give a reasoned opinion, reasons, saying that, okay, let's say the state brought 10 witnesses. Bernard Avlet said this. Bawadua said this. Jude Duncan said this. Hansen said that. And at the end of the day, I think that you accused person, Mr. XY, you should come and answer. So the judge will explain. So the example Tokonu, so giving that example, Tokonu is saying that she has not seen what the petitioners have said, which has found favor with the Council of State and the President, and for which reason they say she should come and answer. So she wants to see that document, what went into it. That one, I think there's some merit in it, but put that aside. So what she's saying is that now that I've not seen the document, if I continue the trial, then by the time the Supreme Court comes to a decision, if they come and say, I should see that document, and by then you finish the investigations, and then I've lost, then it means that the Supreme Court decision will be useless. So you even call it, in Ghanaian English, we say the Supreme Court decision is a foolish case because it would not have helped me. So because I'm likely to win the Supreme Court case, and not just likely to win, because I'm going to be irreparably harmed, the harm I'll suffer cannot be compensated in money, she wants the committee to stop the work. That's what the meaning of the injunction says, stop the work and wait for the Supreme Court to go into the case to see whether, for example, I'm entitled to see the basis on which President Mahama and the Council, who is President Mahama, but advised by the Council of State, said I should come and answer the charges. Is that clear?
That's very, very clear. But it's the same Supreme Court which then sat on the matter today and said, we don't agree with you. So that's quite interesting, right? So maybe one day, in a different world, we could have a separate court. Because sometimes I, as a non-lawyer, I ask myself, how can a Supreme Court sit on a matter in which the Supreme Court's name has been brought? Do you understand? Because somebody says, the Supreme Court has not finished its work, therefore the committee should pause. This same Supreme Court sitting on that matter and says, no, we've not finished our work, but we can still let the committee do their work while we finish our main work. Maybe in a different constitution, we could say, let there be a court of arbitration or something, some other court to look, because it seems a bit weird for a court to be sitting on a matter in which somehow its name has been mentioned, but that's for a different argument, I'm sure.
Yes. Yes, there's something to be said. So that particular one there, it will be interesting because that one, going by even layman argument, it makes sense because she's simply saying on what out of the petition, which of the grounds, which one found favor? Are you saying everything found favor, or maybe 60% of it found favor, or 99.99? So that one, I just hope yes, that one going forward, we need to look at it again. And I don't see why that one is difficult to deal with. You know, when Professor Kweku Azar petitioned for the removal of Justice Tokono, Ekufuado dismissed it. And you know, he brought his lengthy ruling. Okujeto said he wrote it. Okujeto said he wrote it for President Ekufuado, but it came out. So I'm wondering why this one, they don't want it to come out. She must see it. Maybe if they even say, look, we'll give it to you alone, the public shouldn't see, fine. But for her to go into the trial and has not seen the basis of the prima facie, that one, I think she has something to say. My only beef with her is her retaining Godfrey Dami to do that case. When Godfrey Dami is being caught on a tape, undermining the whole judicial system, suborning Japa, coaching Japa to go and lie to the court, coaching Japa to go and, you know, get a fake medical excuse duty, etc. You don't reward such bad behavior. Elsewhere, elsewhere, Godfrey Dami's license would have been revoked a long time ago. You see what America they did to Rudy Giuliani. You see what they did to Rudy Giuliani? Hey, Charlie, those days when Giuliani was mayor of New York, hey, Charlie, Giuliani was the man. You see, when he breached the rules, they didn't say this was a great mayor of New York. So they revoked his license. In a serious country, Dami wouldn't have had a chance to practice law by this time. So Tokonu going to retain Dami there, it's not on.
Well,
I think
I'm sure you know that somebody has petitioned the General Account Council on this matter. So I believe we should allow that process to play out. Your views on Dami are well known, and I'm not here to try him. So I think that's a fair one. But I thank you for bringing light, as always, to this matter. We have been speaking to Martin Kwebu, who's a lawyer, following the matters that happened in court today. We'll take a short break. When we come back, we're delving into Bernard Intribuesiako, Chairman Wontumi, who had been invited by the police. Indeed, it's a three-piece issue. Initially, it was an attempt to arrest him in his home. That was botched. Then he was invited to the police. He went and released. On his way out, the Yoko grabs him, and he's not been able to come out of Yoko. We understand he's been granted a 50 million CD bail, which his lawyers are sweating to, I don't want to say what's the technical word? They basically are trying to meet the conditions. So we'll come and speak to some lawyers on that. My guest in studio is still here. The point of view is live. Stay with us.
Introducing Betway's Bet Influencer, a groundbreaking feature where you can make money by just sharing codes. He just needs to share his codes and make money. The more his codes are used, the more money he makes. Oh yes, so what are you waiting for? Anyone can be a bet influencer. Share your codes and make money. Bet Influencer, another world first from Betway.
This advert has been approved by the Gaming Commission of Ghana. Betway, get way more.
Remember who we are singing now. At risk of prostate enlargement. We remember or 20 ebitiminya prostate cancer. 5 bitimi afamu nadia ubefamu.
Actually, this is not my fault.
And to wada, entina midi menichi Executive Prostate Center.
Executive Prostate Center is a unique medical center where we harmonize in-depth traditional medicine with cutting-edge science and technology to cure, to treat, and to prevent diseases like prostate enlargement, prostate cancer,
Executive Prostate Center. Madame home. Facilities no any professional medical care.
Sisi a bibia clear wo system ni. Ye nro ne so de natural. Into we koso afa ma ye.
Executive Prostate Center. My cured.
Welcome back. Tonight we're live on The Point of View. My guest is MP for Bongo, who is in the person of Charles Bauer. Is Dua, not Dua, Dua. And he's a lawyer himself, and he's talking to us about some of the big cases. We started off with the CJ matter, spoke to Martin Pebu. Now, let's turn our attention to Chairman Wontumi. Chairman Wontumi has been in the news for a number of reasons. So, a few days ago, a team from the security agencies tried to go and arrest him in his house. Somehow, they botched that attempt. People had massed up there, but for some reason, they decided not to arrest him. And then he was invited to the police CID, which invitation he honored. Now, let me just play a quick audio or video of what he said to the media about that CID interaction.
Me lance a ye lease at the chair woman said menye illegal mining. Now said menye galamse and tea me de me lances no at the chair woman ama omuhnuye. The tosu bio almost aka say me ye juma ewo forest. And also me catch from say enyemia me nkonko ye juma ewo forest biya mu. Aye so mo evidence omo betimi e dey ashre me.
The Ashanti Regional Chairman of the NPP also refutes claims that he received any improper payments from Cocoa Board following media reports that his construction firm Hallmark Civil Engineering received about 50 million cedis.
Anya no credit sama je Cocoa Board for sika. Obia no so wo kọ no wakwakoye road anya ban na mauska. Aye wo mum na wo du sika ebekọ contractor no wo na wo du sika bekọ na wo de akwakoye road. Ubia na highways for the Cocoa Board for no omo engineers.
So that was after the CID conversation, which he explained had to do with allegations of some mining matters. Now, on his way back to where he was supposed to go to from here, a team from Yoko then arrested him, leading to very, very interesting scenes at Yoko the same night. I wanted to show you some of the Yoko footages, which included supporters massing up there. At some point, military men had to be sent there to try and bring calm. A news reporter was attacked by some supporters of Wontumi for something he said. This was quite tense. Charles, our Charles, not you, the Charles. we also have a Charles. Our reporter Charles spent almost the whole night there. Umaru Sanda as well was there. This was quite a tense scene because Yoko had grabbed him. So first, I want to clarify from the MP here. It seems as if this is some way. First, you go to the man's house to try and arrest him, and for some reason you are not able to do that. Then you invite him to the police and he shows up. You finish talking to him, he's going home, and then you go and catch him again and send him to Yoko. It's like a scene 3 of one movie. What's going on? You are in parliament, you understand this. What's your understanding of why the man is being taken through all these installments of questioning and attempts to arrest and all that?
Bernard, let me say that for me, like I have been in this legal practice for many years. What has happened is not new.
Okay.
I mean, the initial decision by the security agencies was to arrest Chairman Wontumi from his house.
Okay.
Now, they got there to arrest him. For some reason, the situation was not convenient for an arrest because, some persons, apparently supporters of Chairman Wontumi, had gathered around and made it difficult for them to effect an arrest. So they decided to leave. He was invited to come to police CID. He honored the invitation, which is fine. And I think he should be commended for that. He comes, and then he is interrogated. My understanding is that this aspect of the interrogation was on the issues relating to illegal mining, mining and polluting water bodies, mining and the forest reserve, and related matters.
Okay.
So the CID invitation was in respect of these things. You can, mining illegally is a very serious offense under our law. In fact, very recently, I think 2022, the punishment for it had been increased to up to 15 to 25 years. So that is a very serious offense. And after he had been interrogated, he was released by the CID. They have finished their part of it. Then another state institution, the IOCO, which also needed him. So you should have a distinction between the CID and then the IOCO, who also needed him, then also pick him up. For other matters concerning the payment of monies to him, you will see that that aspect of it is an alleged economic crime, which is alleged to have been committed. And I say alleged because, before a man is proven guilty under our law, he is assumed to be innocent. So it is this aspect of it that the IOCO, I am informed, invited him. He's been interrogated. The practice is to release the person on bail. He has been released on bail on terms, the terms of which I think he's now trying to meet. So it's not the case that he has been refused bail.
Yeah.
And I'm not sure that they would have refused bail. Otherwise, they will have to go to court with him tomorrow.
So he's been granted bail, but he's not been able to
execute
the reason we've not been able to bring his lawyer into the studio is partly because of this matter. That from the last time we spoke to our reporter at the IOCO, they are still in there.
Exactly.
Trying to organize the things around the bill.
Yes,
and therefore
to meet the conditions.
Yes.
And that's where, I agree with my learned friend Martin when he talked about the processes surrounding bail. I am not sure that Wontumi, as we know him, is incapable of owning property worth 50 million.
He can.
I'm sure he will.
Yeah.
You understand? So executing or satisfy a bail condition for 50 million should not be a problem. But, the processes are quite different. And I'm sure that is why he's trying to clear, and get out. So these are the distinctions.
Some people...
And let me say, before you go, that, look, arresting people over Galamsey and all, it's not new. My constituents, who live Bomo, they go to Western region and other parts, to get their daily bread, have been arrested. Some have been brought to Accra, were arrested in Western region, brought to Accra. I am moving with lawyers from police station to police station, court to court, trying to get bail for them. Some of them get bails, but the conditions are such that they cannot meet because they are with justification. So it's a daily occurrence in our court. So what is happening to Wontumi is nothing new and should not be politicized as if he was being targeted by some political party or by government.
Some people complain about the way he was arrested or the way IOCO picked him up. Indeed, the MPP executives we spoke to yesterday, Hanabuachi, Titus Glover, some describe it as a Rambo style. Rambo style. I don't know what you have to say about that.
I don't know what is meant by Rambo style. I haven't seen the videos how he was picked up, but I believe that he was put in a vehicle and driven to IOCO. I don't know what is Rambo about that.
Why couldn't IOCO just invite him like they did, like the CID did?
No, I mean, if you have the person before you, why?
The man had just finished going through interrogation at CID.
Yes. And nothing stopped
And he showed up on his own volition.
Exactly.
So why didn't they say, hey, by the way, IOCO also needs to come?
Yeah, but
why did they have to go and pick him up?
No, what is wrong with picking him up?
I'm just asking.
There's also nothing wrong with picking him up, so it's a choice. You need this man. You see the man. You pick the man up. There's nothing wrong with picking him up.
Yes.
It's not as if he was maltreated. I don't think that the allegation is being made that he was maltreated.
No, but I think the question has to do with the way on his way. Okay.
He was immediately taken away.
Let me ask, because I also heard Mr. Abankwah Sechere of the MPP this evening on the CNR even make reference to the dark days, and I urged President Mahama to intervene because he felt like there's too much, the thing was shrouded in too much mystery and why is the man being held and all of those things. I just wanted to.
So it's simply because we have decided to politicize this thing. Maybe because it's a politician. These are things which happen to Ghanaians on daily basis.
So this is normal.
It's normal practice.
Let me ask Mr. Kwebu if he thinks it's normal. Mr. Kwebu, I believe you're still on the line. And have you been following the Wontumi matter? My colleague in the studio is saying that it's because of the politics that it has been raised the profile, that from the attempt to arrest him to his invitation by CID and his honoring it, to his being picked up by Iyoko, he doesn't see anything unusual there. Some MPP supporters have complained about all of this. Again, when you put that through your legal lens, are the security agencies on all fours?
Well, Bernard, so my comment is based strictly on what I've seen, the kind of information I've received, right? So my first comment is that this morning, yes, I think it's this morning, I heard lawyer Pia Kubi, who is one of the lawyers for Chairman Wontumi, commending Iyoko for being very professional, extremely professional. Also, me bo mabaso and other words. That's Apia Kubio. And we all know that apart from the businessman matter, the one that the businessman brought money to Parliament and Apia Kubi refused to disclose the identity of the businessman, he is generally known to be forthright. He's a straight talker. It's Apia Kubi who led the charges against Oforiata, etc. There are a number of things he's done well. It's just the businessman thing that he refused to reveal the identity. So generally, he's far better than the average politician in Ghana. He's generally trustworthy. So he came out to say he's commending Iyoko for the manner in which they've dealt with this case. Okay? He was asked about access. And to be candid, maybe your producer can look for the tape. It was on NEAT FM, very early in the morning. NEAT FM. The journalist was Mark Jerry. NEAT FM, I'm sure you know how to get it. You can pull the tape. So since then, I've been very careful because prior to that, I had heard they said they had been arrested in Gestapo style. Bernard, Honorable Dafema says we should stop using Rambo style and go for Gestapo, the Russians. Can you hear me?
I can hear you, yes.
He says we should say Gestapo style, right? So Apia Kubi, who is part of Wontumi's lawyers, has come to debunk that. So I will wait. I don't want to rush. You know, in the last few weeks, I've learned some lessons. I think the attempt at disinformation has gone up a few notches higher. So now I'm a bit hesitant. You know, for me, I'll do straight talk based on the information I have. But I've seen that increasingly some people will put out false information early. Then people will go and say, oh, yes, I'm with them. Only to later, I'm being careful. I'm being careful. We are learning fast on this job. So me, I'm saying that even his own lawyers are commending Iyoko. So when a man's own lawyer comes to commend Iyoko, I would take that over somebody who is standing, let me say, he's not exactly a passerby. Yes, they are also MPP apparatchiki or executive. But this is the lawyer. It's the lawyer who entered, and the lawyer is commending them. Bernard. Then number two, you see, yesterday night, they gave bail. I'm even very happy. Bernard, if somebody is in custody and they say we've given bail at this, what do you call it? With this sum of money, it's a huge step forward, extremely huge. If you somebody is arrested, listen, around 3 p.m. or so, and then by 11 p.m. we are told that they've admitted him to bail. It's a huge step forward, right? Then at least you know that there are not going to be some, excuse me to speak Ghanaian English, no wagadre, etc. It's a huge step forward because you know Iyoko, I went to court. 48 hours is 48 hours. That's Martin Kpebu number 4 versus Attorney General number 4. They could have kept him and waited maybe 1 hour to the 48th hour. Then they'll go to court and try to seek extensions. You know, Edu Buahin spent some days in Iyoko cells. They could have done that. So for Mr. Raymond Acha to give bail, they announced bail, they said yesterday around 11 p.m. and he was picked up around 3 p.m. So if you deduct, so give it about 8 hours. Even if I'm wrong, maybe 10 hours. But they said it was yesterday night, not this morning.
Okay.
So it's a huge step forward. That way, when I heard it, I was excited because, you know, though I want Chairman Wontumi to be held accountable, I'm not one in favor of tricky pre-trial detention because, you know, I've gone to court on 3 occasions in the area around bail. You hear Martin Pebu #1 versus Attorney General #1. Martin Pebu #2 versus Attorney General #2. Then Martin Pebu #4 versus Attorney General #4. These are various aspects of bail. So me, Charlie, we need to fight for personal liberties. So for Ekufu will tell you that personal liberties are priceless.
Wonderful.
So once they've announced the bail, it's a good step forward. So for me, that is what I see.
Thank you. Let me take a short break and come and wrap up. I will also go over to Yoko because we are still in the process of speaking to one of the lawyers for Mr. Wontumi to see what the matter, whether they've been able to secure bail. Stay with us. We are live. We'll be right back.
To get polytank.
Oh, and you're fine.
Go straight.
No, I want to left, right.
That's right. Ghana na yewono. So when you jomwa and ye data. Who knows? Abe, na here. Me pe polytank ato. Enu ti sameni ya ba yo ti be na ba yo. O fu ti be ya. Ese entwa ye kura.
Akuya bulambo kotoman. Emu ha.
Like they take you by so. Go to the distributor and you give the original polytank. Polytank. You get a sound?
Polytank. Papananka Sankasa.
Excellent. Be that business owner that stands out and is very productive.
You're so confident. How do you do it?
It starts with Build. Where does your confidence come from? Paperwork made simple. Build takes all the hassle away. Yeah, don't be like her. Build is your all-in-one simplified finance platform. It's your home for invoices, payments, your payroll, and so much more.
Oh, wow.
Grow your business today. Sign up now at build.africa. Download the Build app now.
Introducing Betway's Bet Influencer, a groundbreaking feature where you can make money by just sharing codes. He just needs to share his codes and make money. The more his codes are used, the more money he makes. Oh yes, so what are you waiting for? Anyone can be a bet influencer. Share your codes and make money. Bet Influencer, another world first from Betway.
This advert has been approved by the Gaming Commission of Ghana. Betway, get way more.
Remember who we are seeing now. At risk of prostate enlargement. We a member or her. 20 ebitimi prostate cancer. 5 bitimi afamu. Nadia ubefamu.
Actually, this is not my fault.
And to wada, entina midi meniche Executive Prostate Center.
Executive Prostate Center is a unique medical center where we harmonize in-depth traditional medicine with cutting-edge science and technology to cure, to treat, and to prevent diseases like prostate enlargement, prostate cancer.
Executive Prostate Center. Madame home. Facilities no any professional medical care.
Sisi a bibia clear wo system ni. Ye nro ne so de natural. Into we koso afa ma ye.
Executive Prostate Center. My cured.
Welcome back. So tonight has been a double header with looking at the CJ and the committee looking into a petition for her to be removed. We dealt earlier on with Martin Pebu on that as well with my guest in studio, MP for Bongo, Charles Bawadua. We've been discussing the Chairman Wontumi matter as well. We need to apologize because we had been given assurance by Wontumi's lawyer that he would speak to us, but because of the pendency of the execution of the bill, we believe he's unable to join us. He and other lawyers, we understand, are still at the IOCO premises. And for that reason, they are unable to join us to comment on the matter, which my guest in the studio says is normal, that sometimes when a bill has been given, you need to move around to put things together. But for a man of Wontumi's stature, 50 million seems fairly reasonable.
Yes, and that's why I'm surprised that they're having challenges.
Yeah.
Maybe authorities are not turning up to execute the bail. I don't really know what the problem should be. I think also that the procedure is quite extensive. I mean, after you've been granted bail, the authorities will have to come. The investigators need to go and visit the residence or houses or locations of the authorities to be sure that in the event that Wontumi doesn't turn up, I mean, they can reach out to those people. And then the investigators also have to be satisfied with the documentation to be sure that they are authentic documents. Sometimes, if it involves landed properties, the police may have to go to the Lands Commission to certify certain documentation. But I think with Wontumi, he shouldn't have problem. I don't know what really the issue is. The fact that he has been granted bail, I mean, closes the matter. Should not.
Let me end with Mr. Kwebu. Martin, on the economy side, most people say the government is doing well. I'm sure they've done about 4 months. On the good governance side, when you see all the matters, attempts to do oral in some of these cases, are you able to rate the government in terms of what they promised and whether they are delivering?
On the economy?
No, economy, I've already answered that. I'm talking about on the governance side. You are a governance expert, not an economic.
Okay, good. Yeah, so governance, but let's put it this way. I can't immediately give marks, but obviously we are making a lot of strides. It's a huge improvement. Let's start this way. Akufo-Addo brought too many kith and kin. Too many kith and kin. They came and plundered us. They were chopping family and friends, about 50 of them, right? At least this president hasn't brought so many family members. It doesn't measure anywhere near Akufo-Addo's 50 odd family members, right? Then number two, the numbers are down. Somebody even said, one MPP communicator complained that JM couldn't even appoint 60 ministers. He promised you do 60. He has ended with 56. And so that's a broken promise, right? Look at the humor in it. So that's also a plus. Then you look at the code of conduct is published. Yes, we are moving towards corruption, making more efforts to curb corruption. So it's good, right? Except that we think it's not biting enough, and we complained that he should pass the bill that is an IMF conditionality. That's the asset declaration law. Let me break it down further instead of code of conduct. We want an asset declaration law that will make it such that when a minister and all the other qualifying people declare their assets, it will be published online so that we can read and know all the details. So that if we see them with other properties that appear to be owned by them but not in the published list, we can report, etc. Yeah, so that side is okay. It's not just okay. There's some progress, a lot of it, right? Of course, naturally, my kind would have wished that more was done.
Okay.
But if we are measuring, so far there's a lot of improvement. And generally, JM is better at press freedom. You see, there is more press freedom, all right? So that's also a mark. It's press freedom for me, even though it's measured as a standalone in this year when you do the annual press freedom, but I also see it as a critical component of governance. Because
Wonderful.
When you have a vibrant media, then it indicates that, yes, citizens are holding public officers accountable, etc. Right? So it would appear that the democracy index would do better under JM, and of course the related press freedom index will do better. So far so
good. Good. We'll have more time to talk about this. I really appreciate your time, Martin Kwebu, and of course Charles. Great to have you. Hope to have you again on other matters. Also, development of the Bongo constituency. The proud people of Bongo. Thank you so much. We'll be talking to Charles Bawadua, who's MP for Bongo, and of course Martin Kwebu, who is a private legal practitioner. I call him the people's lawyer. Thanks for watching. We'll see you next time. Have a good evening. Bye-bye.